Good morning, Central Florida, and welcome to another edition of the DeWitt Law Review right here on 107.3 FM and AM 580 WDBO. Remember, the answers and information given on this show do not constitute legal advice. If you do need legal advice or legal assistance, please give the office a call at 1-800-DeWitt-Law. That's 1-800-339-4885, or you can visit us at DeWittLaw.com. I am attorney Moe DeWitt, and joining me this morning is attorney Jacob Stuart. Welcome to the show, Jake.
Moses, it's great to be back.
It's great to have you back, and we wanted to bring you back in because we have been following the Charlie Adelson trial up in Tallahassee, Leon County, Florida. Very interesting true crime story that's been going on for a better part of a decade now. They just had the trial of the, what are we on now, the fourth defendant in this case.
Right.
And so we're going to get to what happened there, but if you wouldn't mind just to start us off for people who haven't been listening to the show or maybe missed the first part where we kind of covered this trial a couple weeks ago, would you kind of just give the background of this case for our listeners?
Sure. So we have back in 2014 a custody dispute that started between an FSU law professor, Mr. Markel, and his wife, Wendy Adelson, at the time. They had two young boys, about 5 and 6. And depending on who you believe, there's no dispute, though, about that he was murdered in his driveway.
Right.
And
in cold blood, essentially.
In cold blood, in his driveway in the middle of the day, right after he dropped his kids off and worked out. And this happened in a part of Leon County where there's relatively no violence or anything. And this case rose to the media because it involved two affluent families and allegedly, her brother, meaning Wendy's brother, being the mastermind hiring gang people from South Florida to drive up and kill him in cold blood over a custody dispute of their two boys.
Right. So, I mean, essentially what's transpired is, both Professor Markel and his wife worked at Florida State College of Law. He was a professor there, and she taught there as well. They were going through a nasty divorce, essentially. Right. They were fighting over custody. She wanted to move back to Miami with the kids. He didn't want that. And so what's been alleged is that the brother of the wife, Adelson's brother, Charlie, then essentially hired two hitmen to drive to Tallahassee and murder the husband as a way for them to as a way for the wife, his sister, to be able to bring the kids back to South Florida. And so the link between the brother and these two gang members who ultimately did the execution was Charlie's girlfriend, who had a child with one of the gang members. Is that correct?
Right. And her name's Katie or Catherine, but goes by Katie according to the testimony. And she was tried twice, but she is the linchpin that actually connected the dots, like you're saying. And part of the reason this case, one, is hard to describe is that there's not a lot of clear-cut evidence. Most of the evidence, if not all of the evidence, is circumstantial. And that's part of the reason, in part, now having heard what the verdict is and having the state come out and make press conferences and statements, them talking about the length of time it took really to build this case with the FBI, with informants and things like that, really setting the case up to be where it is now.
Well, I guess we should jump right into it because a verdict has been reached in this case now after a trial that was, 2 or 3 weeks long? It
was almost 2 weeks, and the verdict came back in 3 hours or less, which as a defense lawyer is a horrible sign.
So I'll let you announce the verdict if you'd like.
Yeah, he was found guilty on all 3 counts, including murder, conspiracy to commit murder, and solicitation to commit murder. And it was really shocking in the sense that, I see things through the prism as a defense lawyer.
Right.
And, I haven't seen the whole trial like we talked about off the air.
Well, you could quit your job and just watch the trial all day.
But for viewers and listeners, when you're a defense lawyer, even if the case isn't going well, you really create what's called a record, anticipating if you do lose, there are appellate issues to get your client a new trial. Right. And you're hoping as a defense lawyer that, especially when a case is really serious and you have a jury of 12 people, which in this case they had a jury of 12 plus 2 alternates, that it takes a little bit of time, meaning a day or two after this long of a trial, for 12 people to be convinced of one thing beyond a reasonable doubt. So if you hear what they call the proverbial door knock, meaning when the jury knocks on the door to get the foreman, in that short of time, it really had to hit them in the heart so they knew it was coming.
So, I mean, obviously very serious case, serious allegations. With them only deliberating for 3 hours back there, I mean, obviously a bad sign for the defense, but what do you make of that? I mean, do you think that there was just no case there, that, any insight on that?
I think from what I've seen, there were 2 really big things that struck me from watching the closing arguments from the state and from the defense. One is that Mr. Adelson in his story or his version of the truth, remember, the defense doesn't have to put on any case in chief.
Right.
They made a decision to put a case in chief. And in this case, the state, even though they have the burden, also went on the attack to attack what the story was from Mr. Adelson. And Mr. Adelson basically said, I confided in my girlfriend at the time about this custody dispute going on. And basically, she used an opportunity to go tell her ex, and his friend about actually extorting, meaning Mr. Adelson and his family for money. And when he got on the stand, it's hard for him even to say it because it doesn't really add up that they would go and kill someone and then say to Mr. Adelson, if you don't pay us $1 million, we're going to kill you and your family too.
Right.
That just seems, and
seems far-fetched.
And it would seem that if they're really going to do that, if I was arguing as a state attorney, that they would have just put the gun to his head and say, we don't need to kill this other person to prove that to you, right?
They just point the gun, like you said, put the gun on his head and say, pay us the money or else.
But as the defense articulated in their cross-examinations and in their closing, that he really didn't have a motive to do it, meaning he had a great life in South Florida. He wasn't particularly close with his, sister or his nephews. Yes, there were emails where he was carbon copied on between, his mother and dad and his sister, but really there was no motive. There was no driving force for him to do this. And so that's why, the comments after the trial are even more interesting now. And I don't want to, make it short in the sense that Mr. Adelson he's right now going to be sentenced to life in prison. The judge did not put his sentence in. He is entitled to what's called a pre-sentence investigation, meaning anytime you're convicted in Florida of a felony and you have no prior criminal history, you have a right to a pre-sentence investigation. But even still, with all that going on, he's going to get life in prison. There's no other option.
I was going to say, there's really no doubt.
Right. And really, though, until that sentence, and once that sentence is entered, then he has 30 days to enter appeal, which I'm sure he'll enter an appeal.
Right.
But the state attorney's comments afterwards about that when they're asked, is the case still ongoing, meaning is the investigation still ongoing, they said it is. And they stated, and quote unquote, stay tuned, meaning they're still looking at Mr. Adelson's sister, Wendy, who was the ex-wife.
Which to date, really, there's been no allegation that she was in on this plot. I mean, there may be some speculation, but we haven't heard of any evidence yet that's at least been released to the public.
No, but it's interesting that after 5 trials, like you said, one of which was a tried and mistrial of Katie, the ex-girlfriend of Mr. Adelson, that they're still saying that they're continuing to investigate.
Because it's been nearly a decade now.
Right. And and remember, in this case we talked about in the last show, before the trial, the state had wanted to subpoena Mr. Adelson's parents.
Right.
And they had notified the state through their attorneys that they were going to invoke their right to remain silent, which in a criminal case, and I think it's similar in a civil case, you can't call a witness if you know they're going to invoke their right to remain silent.
Right.
And so one could say in the court of public opinion, why would you invoke your right to remain silent? On the other side, of course, you have the absolute right not to be compelled to testify against yourself. So these commentary that maybe the sister had nothing to do with, or the daughter, Wendy, had nothing to do with it, Mr. Adelson's sister, but this idea that his parents were there, and it came out through testimony as well. I think it's important for listener and viewers to know that Wendy's ex, so to put a time frame on, her husband's murdered. She then gets a new boyfriend. That boyfriend, sometime between 2016 and 2018, is told by her that her brother actually was involved and actually paid for it.
And I believe he testified in this trial, correct?
He did. He came out and testified that. And I think that's another really big death blow, because now essentially you have someone who is not biased. Meaning
he's a neutral bystander.
Right. It's not Mr. Rivera, who's the hitman. It's not Garcia, who was, the actual guy who pulled the trigger. It's
not a gang member.
Right. It's not a gang member. It's not a convicted felon.
Yeah.
It's not someone who, Katie, who admitted in her prior trials that she had lied. You had someone who essentially, for all intents and purposes, was neutral, was just there to tell the truth. And I think the state really hammered that home in closing argument.
Yeah. No, and very damning to their case, obviously. I mean, what do you think about Charlie Adelson taking the stand? I mean, in a case like this, a serious criminal case, you don't often see a criminal defendant take the stand. Usually they invoke their right to remain silent. Here he took the stand. He put this theory on in front of the jury that, this double extortion plot where he was extorted by these gang members, and they basically said, we killed Dan Markel, we're going to kill you too if you don't pay us $1 million. What are your thoughts as a criminal defense attorney, somebody who's handled these kind of serious cases many, many times? Was that a mistake on the defense's side? Was that, the Hail Mary? They're just going for whatever they got. What are your thoughts?
Well, I think as a trial lawyer in a criminal defense case, you have absolute control of strategy in trial, except for if the defendant wants to testify.
Right.
And if a defendant chooses to testify, no matter the case, the judge outside the presence of the jury is going to do a colloquy, which is a fancy way of just saying, making sure the accused, the defendant, understands they have a right to remain silent, and it's their sole decision to testify. And so I think that's an important context and prism to see this case in, because in general, especially in cases based on circumstantial evidence, allowing your client to be cross-examined, you better be really confident and sure they can survive that. Yeah. And you really should have, for all intents and purposes, a really, really good testimony or a narrative.
Yeah.
And in this case, Moses, and I guess it's easy like to play Monday morning quarterback, or
of course, yeah.
Right. But looking at the case as it was, it would have been my instinct to recommend him not to testify. And his attorneys may have done that. His attorneys may have said, you shouldn't testify, but
Absolutely.
I'm going to do it anyway.
Yeah, we never know what's going on behind the scenes, obviously.
But the way, meaning Mr. Adelson, when he was cross-examined, I think that, he actually, during part of his cross-examination with the state, was actually commenting or giving commentary on the overall case in chief.
I heard that, yeah.
And so you got to remember, for the viewers and listeners, this is a wealthy doctor coming from South Florida into a very small, even though it's the capital, rural town in the Panhandle in Leon County. And you have to be really careful with optics. The trial system is one of the best in the world, but it's not perfect. And optics really matter. And whether that's how you look, how you talk, where you're from, all of those things really matter in considering the testimony. And I think ultimately it really hurt him, because when the jury heard and him being cross-examined on this double extortion idea, it's just really hard to explain that.
Yeah, I mean, as the defense here, they really had two options, in my opinion. They could go with, putting on their own theory, which is what they did, this double extortion theory, or they could go the route of reasonable doubt, basically. The state has not proven their case. You have not gone beyond a reasonable doubt, and just poke holes in the state's theory. Obviously, they decided to present their own theory, and here the jury did not find that credible.
Right, and it's risky, like you said. I mean, a lot of times, unlike in a civil case usually, in criminal cases, you can really, part of what, as a defense lawyer, you start with in jury selection, through opening statement and through closing, you talk about how you should start as a juror with the absolute 100% presumption that someone is innocent. Right. The state has this incredible burden to meet. And a lot of times, like you said, you just poke holes and you be very aggressive about that. And that usually can be very fruitful. Unfortunately, in this case, they made a strategic decision, and ultimately on appeal, we'll see what happens. One of the things that it talks about is the FBI call that came in, whether or not that creates an issue for mistrial. But, he's in a really serious situation. I think, again, the state, forecasts, foreshadowing that the case is not over. Who knows what's going to happen now at this point?
Yeah, that's pretty scary for the remaining potential defendants. But I do want to jump into Rivera's testimony, who was one of the two gang members who drove up to Tallahassee. Not the trigger man, but the driver of the vehicle. He drove up to Markel's house while the other person got out and pulled the trigger.
And it's important for your listening viewers to remember, this is the only eyewitness of the murder. So this is why this testimony is critical, and we wanted to play it for everyone to hear.
He had turned he turned the block before. We kept going, so we went in front of his house. So when he pulled in, we pulled in right behind. I pulled in right behind him.
Is what you're describing, you entered his street from two different directions?
Yes, ma'am.
All right, and you met at did you meet at his driveway?
Yes, ma'am.
Okay, so you pull in behind him, what happens next?
First, he had jumped out and shot him.
How many times?
Twice.
Where was he standing when he fired the shots?
Right in front of the driver's side, by the driver.
Did you see what the victim did during this attack?
He put his hands up.
How was it decided that Mr. Garcia would end up being the shooter instead of the original plan, which was for you to do it?
I was driving. I ain't had no time. He jumped out and did it.
So pretty damning testimony. Like you said, the only eyewitness to the crime, puts them there at the scene, admitting to it. And later they make some links to Charlie Adelson as well.
Right. And I think it's important to remember the state has to prove the body of the case, all the elements that a murder happened.
That's a good point, yeah.
And so having him testify to what happened and the credibility of that is an important maneuver by the state, because then if you believe his testimony of what happened at the scene, then you're probably going to believe as a juror when he says he got paid $35,000 by what he called the dentist, which he's referring to as Mr. Adelson.
Right.
So his testimony, even though he cut a deal for 19 years in prison, becomes that much more compelling. That's why I think it's a critical part of the case.
Absolutely. And we have plenty more to cover in this trial, the trial of Charlie Adelson. We'll be right back after this break. You're listening to the DeWitt Law Review on 107.3 FM and AM 580.
All right, the crash happened. I was at a stop. The car was coming in, rear-ended me from behind. I was trying to get out of the way, but yeah, that didn't happen. Yeah. After the crash, I just kind of sat down for a couple minutes, gathered my thoughts, after the ambulance and stuff. Got discharged, went home. I was really trying to think about what to do next because, that was my first accident. Of course, you hear all the time, call an attorney. So I wasn't really sure what route. I reached out to a friend of mine and she was just like, hey, I have someone you can reach out to. And she said, just call Moe.
Many of our clients are referred to us by friends and family, just like in Jamal's case. It was an honor to be able to represent him and ultimately fight to get him the compensation that he deserved.
My experience with Moe was really good. His team, his staff, very informative. I received all the information I needed, step by step. They made sure I was satisfied with everything, and everything has been really good. They're very detailed. They're very, they call or text whenever they make a move or whatever they're doing. They're mailing out a letter, anything. I'm always in the know. So that's really good on their part. So yeah, if a friend or family member, anyone would ever ask me if they need an attorney, I'll always say, just call Moe.
Welcome back to the DeWitt Law Review right here on 107.3 FM and AM 580 WDBO. I'm attorney Moe DeWitt, and joining me this morning is attorney Jacob Stuart. We are covering the trial of Charlie Adelson that is taking place in Tallahassee. Now, right before the break, we heard some very chilling testimony from the getaway driver, for lack of a better term, the only eyewitness to the crime, who actually saw the murder of Dan Markel take place. Jake, what do you think of that testimony? Is it credible? From the criminal defense perspective, how would you handle that?
I think within what prism you present it to the jury is it credible. Remember, when we listen to a clip like that, the jury's already been heard 3 days of jury selection, opening statements, and other witnesses. Now, this witness, Rivera, is critical because he is the eyewitness from the state's point of view that connects all the dots. Right? And so Garcia, who was the baby daddy, to use the colloquialism or colloquial term, with Adelson's ex-girlfriend, is the connecting point. He, though, is the only person who took a deal like we talked about. So if you're a defense attorney, your point of view is, no matter how calm or collected he is, I bring to the jury's attention, and for people who are listening, you can't see it, he's wearing the Department of Corrections, uniform.
Right.
He's in shackles. He's got tattoos. He's a self-admitted gang member who, for $35,000, according to his testimony, agreed to drive up to kill someone in cold blood and drive back down. Then what does he do? He buys a motorcycle with it. And so from our point of view, you're then asked to take that leap of faith as a juror and believe not just clear and convincing, which is a feather in one way or the other, but by one of the highest standards in American jurisprudence. So as a defense lawyer, of course, I would attack, any time someone testifies in court, their motive, bias, or credibility, those three things we call the Trinity in cross-examination, are always open. And so from my point of view, even though he was calm, all of those factors really mattered in the sense that there's no video surveillance to back up what he's saying. The physical evidence you listen to his testimony going on, they never recover the gun because somewhere between Tallahassee and South Florida, they threw the gun in a river. What river, what exit, they never knew.
Nobody knows.
Right. The cash that supposedly Adelson paid, they never were able to actually retrieve that cash in terms of...
And that is interesting. I don't mean to cut you off.
You're fine.
That is interesting because, he says he witnessed the murder, obviously, and maybe he's credible on that. The link between the two gang members who drove to Tallahassee and committed the murder and the dentist, their periodontist, Charlie Adelson, who's on trial today, there's not really a direct link there, even through his testimony.
Right. And Adelson actually says the opposite. When we talk about his, remember, in defense cases, it's very rare I advise the client to testify, because usually the right to remain silent is a very powerful weapon. And going back, you've picked a jury that is presumably, if they keep their oath, doesn't need to hear from the defendant.
Right.
Right. In this case, the defense has made their point very clear that Adelson was actually the subject of blackmail, that these people actually said that they were going to kill him, going to kill Markel, because they wanted to then bring him into all of this to somehow then have him pay them so that he wouldn't be associated with this. And I think that's, it hinges upon, his ex-girlfriend, who we're going to hear from in a second, and her credibility in terms of being involved in this matter. And as you may suspect, everyone is throwing Adelson under the bus now.
Well, at this point, they all have an incentive to. So,
Right.
But I want to talk about the defense's theory. I want to talk about that blackmail right after this break, unfortunately.
Right.
You're listening to DeWitt Law Review right here on 107.3 FM and AM 580 WDBO. I am attorney Moe DeWitt. Joining me this morning is attorney Jacob Stuart, and we will be right back.
And I got hit so hard that it spun 180 degrees facing the way that was coming from. Every Friday morning I go and pick up bagels for my sons. It was raining that day, left-hand turn only lane, and just waiting for the arrow to turn green. Made it about 3/4 of the way up and just got hit from the side. Didn't see it coming. For a few moments I was just like, what had happened? I started to look around, saw that one of my windows was blown out, the airbags were out, and realized I was in a car accident. I was able to move my vehicle and get out, but then as soon as I got out, my neck was just in pain. We ended up going to my primary care doctor, went through the evaluation and all that, but the pain just wasn't going away. Luckily, it could have been a lot worse, but it still leaves me vulnerable to this day. I just remember a friend from the radio suggesting that I just call Moe. He picked up and talked to me. He was at a conference, I think, talked to me and set everything up for me. The process was awesome. Any questions that I ever had, it wouldn't even be a day that they would get back to me. They put me at ease when it came through the whole thing. The process was almost 2 years, but at the same time, I felt like I didn't have to worry about anything. I knew that they had everything under control. I would definitely recommend Just Call Moe. It was great working with them and having them work for me. Like I said, it took a lot of worry off. So yes, I would definitely recommend Just Call Moe. If you're injured on the go, just call Moe.
Welcome back to the DeWitt Law Review right here on 107.3 FM and AM 580 WDBO. I am attorney Moe DeWitt. Joining me is attorney Jacob Stuart, and we are covering the trial of Charlie Adelson, a murder trial taking place in Tallahassee, which, if you like true crime, this is a very, very interesting case. I recommend you follow it. Before the break, we were just kind of diving into some of the witness testimony that's been going on in this case. We had testimony from the driver of the vehicle who was with the actual shooter who committed the murder. And, very important to the prosecution's case is, of course, linking the actual trigger man to the defendant here, because the defendant is essentially on trial for murder for hire.
Right.
He supposedly hired these people to murder Professor Markel. And so I want to kind of dive into the testimony of the girlfriend, which is the state's supposed link between the triggerman and the defendant. And I guess we should just jump right in and play that.
If I could, though, just real quick, Catherine Magbuana.
I'll let you pronounce that.
Yeah, thank you. We'll say Catherine for the sake of that. This is the clip we're going to play is the start of the cross-examination from Adelson's lawyer. So think about this. The state's already given her direct. And remember, when you listen to this, this is her third time testifying in court, meaning she testified in her first trial that was a hung jury, the second where she's convicted, and now third time testifying. And in addition to that, she's also met with the state 3 different times to enter what's called a proffer, which is usually some type of recorded interview under oath that you do with the government entity with the understanding you're given immunity or some type of deal because of that.
Right.
Very rare to do after conversion. So take that into context when listening to how the defense attorney is approaching it.
Again, you lied when you testified that you didn't know anything about or were involved in the murder of Professor Markel, right?
Yes, sir. I told you I lied in my first and second trial to save myself.
Ma'am, we've heard it. If you could just answer the questions. Did
Yes,
you
sir.
lie?
Yes, sir.
You lied when you testified that you knew nothing about Wendy Adelson's divorce.
Yes, sir.
You lied when you said you didn't pick up money from Charlie's house on July 18th.
Yes, sir.
You lied when you said you knew nothing about stapled cash.
Yes, sir.
You lied when you said you didn't bring the money to Sigfredo or Luis Rivera the next day.
Yes, sir.
You lied again when you said you worked as a personal assistant for Charlie, right?
Yes, sir.
You lied repeatedly when you tried to discuss what had happened, what was being spoken at Dolce Vita, correct?
Yes, sir.
All right, well, now let's talk about the lies that you told that the state didn't go over with you. Let's talk about your proffers, your cooperation.
Yes, sir.
Clearly attacking the credibility there.
Right. So I think the big leap from the defense's point of view that I imagine they're going to make to the jury, and they have made an opening statement now in closing, is that the crucial linchpin of the state's case in conspiracy, who self-admittedly has lied not once but twice under oath in trial, just like in front of juries in the courtroom today for Adelson, you're now supposed to miraculously believe her.
Right. Yeah.
And again, this isn't a case where it's just a feather one way or the other. This is beyond to the exclusion of any reasonable doubt. And if they don't have that, she admits to lying there. She admits to lying about the money. She admits to lying about what was said during the FBI surveillance that we talked about in the previous segment. Right. How are you supposed to believe her today?
Well, and also, she admits that she lied to save her own skin before. That was her intent, in the first two trials when she was on trial for murder. And essentially, you can make the argument she's still doing the same thing. She's lying here to give the state what they want in hopes that she can save her own skin and get out of jail early or get some sort of deal from the state.
That's right. And also, I think it's important to remember a jury who presumably have been picked who are not members of gangs or have failed members of gangs. Think about the world they're hearing about. That she now, who is someone who self-admittedly has lied multiple times under oath, is now telling the truth about an organized crime to drive people from South Florida to Leon County, Tallahassee in Florida, to murder someone in their driveway. And she's asking you to suspend all of her prior disbelief and just believe her now. And that's a really hard pill to swallow. And if I was the defense lawyer, you saw his style. He was really attacking her over and over again. And if listeners or viewers want to go watch the clips, they're on YouTube and things like that. But something to pay attention to is that he mentioned right when we turned the clip off that she made a proffer. And we talked about how unusual that is after a conviction. And that's something that I imagine they're going to continue to hammer. So if you're the defense lawyer, those are like their two star witnesses. And then we have some clip of actually Mr. Adelson himself to testify if you'd like to still listen to that.
I would, but before we jump into that, so when you say she made a proffer, she met with the state attorney's office, with the prosecutor, and obviously gave a recitation of the facts of what happened. Supposedly she's supposed to be truthful and tell them what happened, but at least at this point in time, from what we know, there's been no deal with her entered into, right?
No, there hasn't, and it's highly unusual to do a proffer after you've been convicted. A proffer usually is a tool used by defense lawyers in pre-file, meaning before the state has arrested you or filed an information against you. You'll use it to try to avoid being arrested. Or one, when you're in a case with multiple co-defendants, you want to cut a deal to avoid really harsh penalties. You'll enter a proffer. And what you say in a proffer, typically, if negotiated the right way, it's like a contract.
Right.
And you outline what the parameters of that contract are with the state before you sit down under oath. And it's usually recorded and usually transcribed.
Now, is it possible that, as part of this proffer that she did after she was convicted, that there was kind of a wink, wink, nod, nod deal? You give us this proffer, you testify, and we'll give you a break. Is that realistic or not really?
It is if it outside of the fact that she's been convicted. That's the thing. Like, I'm in a trial right now that's in the news, not as much as this, where one of the co-defendants is testifying for the state, but has been guaranteed no deal, but there's understandably a wink, wink, which we're going to talk about in trial. This is just unusual because she's already been sentenced to life in prison. I imagine she may file a motion for judgment, equivalent of judgment notwithstanding the verdict, asking the judge to modify it based upon her good behavior. But it's a real long shot.
Well, and even the state only once you've been convicted, the state only has so much they can do because the judge has sentenced you. There's only so much they can do to overturn it.
And I imagine, as the state has done, that's part of their way to try to cleanse her motive.
Right.
However, if you're the defense lawyer, again, you're asking the jury to convict someone and sentence them to life in prison on the word of a convicted liar.
Right. Well, let's jump into the defendant's testimony because I think it's first of all fascinating that he actually took the stand in this case, and his testimony is pretty interesting too.
It is, and just for the viewers and listeners, before we play it, remember, in defense cases, when you're representing someone, especially in a case of this nature, having someone testify who's accused is extremely high stakes. Because remember, in a criminal case, every single witness is deposed if the lawyers are doing their job, except for the defendant. And no one knows what the defendant will say unless they were recorded in an interview or something like that. So in this case, outside of the surveillance videos and emails they had, no one had ever heard from Adelson himself. And so I'm going to go ahead and play it, all right?
Do you remember yesterday saying you were telling a story about Katie coming in from having had some kind of altercation with Garcia, and she had reported that the necklace had been pulled off her neck. Do you remember that?
Yes, I do.
All right. And when you were relaying that story to the jury, you used a specific term describing what Garcia had done to her. Do you remember what that term was?
It was only yesterday, but you'll have to refresh my memory how I described it.
You said he roughed her up.
That's accurate.
And that put my antenna up because that roughed them up is the exact same phrase that Catherine Magbanua said in her proffer that you used on Halloween 2013 when you first approached her about, does she know anyone who can rough someone up?
No, I think getting roughed up is an adjective, but what you're doing is the same thing you did with your TV theory. Is like you heard TV mentioned multiple times, so you put the whole case together with the TV.
Okay,
and
we'll
you're
get
putting
to
the whole
TV.
case together with the word roughed up. Like,
yeah, I mean, I'm not putting the whole case together.
One moment. Don't speak over each other.
But that's
Please wait for him to answer, then you can ask your next question. Go ahead.
But that's an unusual. I mean, it's a specific term. I'm not making a whole case out of it, but did you say roughed up in both places?
Katie was roughed up by Sigfredo when he tore the necklace off of her neck, yes.
And isn't that the same term you used when you first broached Catherine Magbanua about did she know someone who could rough up someone else?
Never in my life have I ever asked her that question. Never in my life. That conversation never took place.
Did you ever hear Donna Adelson refer to Dan Markel as stupid?
No.
So a couple things there. We chose that one because just like before where you had the cross-examination of Catherine, this is the state cross-examining Mr. Adelson after he'd done his direct testimony. It's very unusual not only for him to testify, but for him to go on and essentially have a conversation in front of the jury with the state about the weight of the evidence and how far-fetched her theory is. It's really high-stakes poker. One, because if he loses, it's his life in prison. But then you heard the judge, intervene, say, "Hey, everyone, calm down. State, let him finish. Mr. Adelson, let her finish talking." And the other big thing is that what she was trying to do there, as an example, he was referring to her as Katie, but that was Catherine, who we heard from before.
Right.
He was trying to say very directly, you're trying to say one thing that I said rough up to make it sound like there was some conspiracy we all said rough up.
Right, or that the language was, the language was similar, so it must have, the story must have been true because I use this term all the time.
Or, not to speak over you, or they rehearsed this type of conspiracy. Right. And so a couple things to think about. The defense has argued, and his testimony was over a few days. This is just only 3 minutes or 2 minutes or 3 days.
Small clip there.
But it's a clip, though, to show you the type of cadence and how really aggressive Mr. Adelson's being, meaning even if he's talking calmly but passionately, again, for a defendant to come on the stand and make commentary about the state's case to the jury is extremely unusual. I would prepare a witness very differently. It's hat in hand, you're already coming from a rich family from South Florida. You're up in the Panhandle. You got this name Adelson. You're coming from the successful family.
Yeah.
You've got to really deal with the optics, right?
Well, not to mention, Miami's about as far different a place than Tallahassee.
Right.
Ever could be.
So you want to really play to, you got to, just like anything, Florida has 67 counties. Each county is a little different. Like you're saying, can't be more different than Broward or Miami-Dade to Leon.
Right.
And so coming in with some humility would be my advice, but they're doing it very differently. The other thing to think about is, and this ties into some of his testimony, he brings the fact up, meaning Mr. Adelson, I love my sister, but my life was not intertwined with hers on a daily basis. We weren't that close. And so, for instance, what they made the argument is, when they were denied the relocation motion, that happened almost a year before the murder happened. It wasn't like this instantaneous day thing. Now, when the murder did happen, it's true that the evidence shows that Wendy Adelson then didn't move her children the next day down, try to change their name, all those things.
Which, you could also say was to be closer to family.
Right.
The father had been killed. They needed more support.
And that's the defense's theme is, this case is essentially, from the state's point of view, the theory of the absurd, a series of coincidences. Coincidences do not equal reasonable doubt. You've got to have some type of string that can really tie them together. And the string they have is very frail. It's very thin, if I was the defendant's lawyer. And so in this case, listening to it, the idea, you would want a smoking gun. You'd want that email. You want that bank transaction or something like that.
Right.
And they really don't have that. And so again, though, having your client go out there, being that aggressive, is a really, really bold move. And looking back at, for instance, the O.J. Simpson trial, you mentioned that earlier.
Yeah.
That case was obviously different. It wasn't a hitman involved. But in cases where you feel like there's not a really strong case, you usually let the jury to decide that, because one, it's the jury you picked, and two, if things aren't going well or they are going well, you really are going to rely upon the record you have for an appeal, because once he testifies, an appellate court may overrule this, say those errors may be de minimis. Look at his testimony.
Yeah, no, that's very true. We'll be back right after the break with some final thoughts. This is the DeWitt Law Review right here on 107.3 FM and AM 580 WDBO. If you do need to reach us during the week for any reason, at the DeWitt Law Firm, you can always reach us at 1-800-DeWitt-LAW. That's 1-800-339-4885, or visit us at DeWittLaw.com.
I had stopped, and for some reason I look up and I see the headlights coming up, and I knew he wasn't going to stop. I'm just sitting there bracing for it, and sure enough, bam. And a couple days later, I woke up and said, oh no, my neck was hurting, back is hurting, and I felt hopeless. I didn't know what to do because I thought it was over. Maybe in that moment, was I supposed to call someone? At this point, is it too late? And I went on the internet. First thing that pops up is DeWitt. And I said, okay, I'll give him a call. We'll see what happens. I don't know about lawyers, because I was the same person. I was afraid of it, to be honest. I thought maybe I'd have to pay them if I lost. I just didn't know how it worked. I think the biggest thing that I can say that DeWitt helped me with was holding my hand through the process of treatment. They actually were able to refer doctors to go to. I got help with my MRIs, with all the scans we had to do on the neck. So there was so much that goes into a car crash process that I truly just didn't know. If you've been hit, call. Simple as that. Because you don't have to do it alone. There's people like the DeWitt Law Firm that will help you. If you're injured on the go, just call Moe.
Welcome back to the DeWitt Law Review right here on 107.3 FM and AM 580 WDBO. I'm attorney Moe DeWitt. Joining me this morning is attorney Jacob Stuart. Jake, just for our listening audience, if someone does need to get a hold of you, they have a criminal defense question or something along those lines, how can they reach you?
They can Google me at Jacob Stuart Law, PA, and my info will pop up, or they can call me 24 hours a day, 7 days a week at 407-545-6416. Even if it's after hours, I get a text message right to my cell phone or a call right to my cell phone. So due to the nature of my work, I'm available 24/7.
Perfect. And if you're just joining us this morning, we are covering the trial of Charlie Adelson, a case that's been going on in Leon County, Florida. He was found guilty on all counts after the jury deliberated for only 3 hours. Obviously not a good sign for the defense there. And, you know, when the prosecutor, the state attorney's office, was interviewed after this trial, they had some comments that were somewhat chilling regarding whether there would be further prosecutions of other potential defendants. Particularly, they were asked whether there would be another trial. And what was the response again? Do you remember?
It's actually, and I quote, "Stay tuned."
Stay tuned, which is not good.
I haven't seen, you know, it's unusual to have a state attorney be that open in public, because there has to be, even when someone's convicted and there's justice, quote unquote, right? Someone's going to go to prison the rest of their lives potentially.
Right.
So there has to be, from my point of view, of reverence to that. And I understand on behalf of the victim and their family, and I'm not trying to downplay that. But the state attorney was almost cute or coy in their response about that, because for our viewers and listeners, this case really, coming from 2014, got a jump start in 2018 when the FBI got involved to do what's called a bump investigation, meaning when they think there's a conspiracy going on, they will, quote unquote, bump someone to actually go and be prompted to talk to other co-conspirators about the case, and they can record that. And that's what happened in this case. And there's been rumors since the beginning of this investigation that Mr. Adelson, Charlie, and his parents were also involved, particularly his mother. And,
right.
you know, he testified that he had no idea, or his mother had no involvement in this whatsoever. His sister, you know, it appears that, you know, the ex-wife to Markel has no involvement in this whatsoever. But it's a really telling thing that after 5 or 4 cases, 4 trials, 5 people or 4 people being convicted now, that they're still now looking for more people involved in this case.
And, you know, based on the evidence presented during these trials that we've seen, there really hasn't been a link that's at least been testified to linking it back to the parents directly.
No, and I think that, you know, they may be sitting on something, which is
It
could be, but it would be unusual. They may be waiting for them to screw up, right? You know,
right.
The idea is that law enforcement wait for criminals or alleged criminals to make mistakes, or people have guilty consciences, right? Or maybe, you know, the son, after being a year in jail, will want to come forward. But there's a lot of different variables. But I think for the most part, this case and fact pattern, we need a flow chart. We've laughed about how complicated it is.
Right, yeah. Trying to explain it to the audience over the air is not the easiest thing to do, certainly.
And so I just think for the viewers or listeners that this case is a classic case of co-conspirators and circumstantial evidence. And it proves that cases that, even if they're not, quote unquote, white-collar crime cases that are about bank records and things like that, cases can be very complicated and take weeks to explain to a jury, but only 3 hours for a jury to deliberate, which means the jury really didn't think much about it at all, Moses.
Which, you know, on the one hand, the state attorney did have a bit of an advantage here. This is the 5th time they've essentially done this case, this trial, because they had the, well, I guess, 4th time.
Right.
Because they had the first 2 defendants, one pled out, one they did a trial for. Then they did 2 trials with Catherine, with a girlfriend.
Right.
One was a hung jury, and one they got a conviction on. And now this is the 4th trial. So they've had quite a few practice runs, which really, you know, can't hurt. You know, practice makes perfect.
No, and you're right. And I think we talked about this in the past, is that the defense lawyer, I'm sure, went back and looked at the transcripts from the past trials.
I would hope so, yeah.
Because that would telegraph. If you have co-defendant cases and they're not tried together, you always want to go look at what the other trials said, because, as you've said, there's only so many ways you can prosecute a case like this. And tying Mr. Adelson in, again, the defense talked about this in their closing, but there was no motive. And if I was the defense lawyer, I really would have hammered that. And I think, you know, even though the state doesn't have to prove motive, juries want to know motives. And that's what you would love to hear, how that deliberation went, for them to get to this conclusion so quickly on all 3 counts.
And even still, the motive doesn't really make a whole lot of sense as to why Charlie Adelson would ruin his entire life over this. Obviously, they came up with the motive with the kids, and that may be why he did this.
Right.
But still, you know, from a rational person's perspective, I don't know why anyone would throw their life away over something like this. But unfortunately, we are almost out of time. Jake, any final thoughts for the listeners about this case, about this trial?
I would just encourage listeners to, you know, to pay attention in the sense that there may be an appeal, or there's going to be an appeal. I would say that with absolute certainty. And that since the state has made it clear that there's continuing investigation, that stay tuned, as the state said, because there's more to see what's going to happen in this case.
Well, there you have it. This is the DeWitt Law Review. We've been covering the trial of Charlie Adelson. Jake, thank you as always for being here with us this Sunday morning. We greatly appreciate your input.
Moses.
Always very valuable input for Jacob Stuart. Again, you're listening to the DeWitt Law Review right here on WDBO